Good afternoon, everyone. My name is Sophie Turenne, and I'm chair of the British Association of Comparative Law, BACL, as we call it. And I'm delighted to welcome you to this Q&A session about publishing in comparative law with the ICLQ. I will say some quick words about BACL and our activities before introducing this session. So for those of you unfamiliar with BACL, the association was established in 1950, and we have about 50 UK universities as members of BACL. And our aim is to promote the study and the teaching of comparative law in the UK. So what do? We arrange comparative discussions throughout the year, and we hold every year a postgraduate research workshop where PhD students present their work and get feedback from specialists in their fields. And I'm very pleased to see some of the recent participants to this workshop in the audience today. We also hold our annual seminar at the start of the Society and Legal Scholars Conference this year on 27th of June at Oxford Brookes University. And I hope to see some of you in person there. And finally, our website welcomes blog posts on comparative law project in whatever shape or form. So please have a look at it, and you will find a wide range of topics being considered there. Please do contact us if you are interested in publishing with us. Publishing is very much at the heart of this session, publishing in comparative law. There's a lot of hearsay, I think, about what it takes to publish. And when it comes to comparative law, well, it's a broad church, and with recurring debates on methodology in particular, and this may make it even more challenging to consider publishing in this field. So we hope that the presentations and Q&A today will actually throw some light on the inner workings and the expectations of the International and Comparative Law Quarterly. To do so, we have some fantastic speakers with us. First, Anna Riddell-Roberts is the managing editor of the ICLQ, and Anna will present the publishing process. Anna has over 10 years of experience working at the ICLQ, and she has worked at the British Institute of International and Comparative Law for many years in different capacity, such as being a research fellow there. So she knows the publication process and what it takes to publish inside out. And Paula Gilliker also knows what it takes to publish and the publishing process inside out. Paula is the Professor of Comparative Law at Bristol University, also the former president of BACL, and currently Vice President of the Society of Legal Scholars. Paula will discuss comparative law submissions very specifically. So this being said, we'll start without any further word from me. So Anna, the floor is yours.
Thank you, Sophie, for the introduction. I have only got 15 minutes, so I'm just going to dive right in. I'll start with a little cartoon. I don't often think this, but hopefully this won't happen to any papers of yours in the future once you've listened to what we've got to say today. So before we dive into the nitty-gritty, there's a preliminary question. Do you want to submit a journal article or include a book chapter in an edited collection? Generally, the answer is almost always a journal, unless the names in the book are the names in your field, in which case adding yours to that group is no bad idea. And sometimes you can republish a book paper as an article, but it's worth noting that the more prestigious journals don't allow this. The next question is, which journal should you submit your work to? Obviously, today we would like to encourage you to submit to this one, the ICLQ. The first thing to do is to check ranking. The Thomson Reuters impact factor is useful for this, and also the research exercise framework ranking of journals, which is UK specific, but it's a good indicator. It's worth noticing that the ICLQ is currently top ranked in comparative law in the Thomson Reuters amongst law journals. Ask colleagues for advice on where to submit a good piece. Where do they publish? It's generally better to only ever submit good work to peer-reviewed journals. If you've got something short or a case note that's time sensitive and might need quick publication, that might be an example of when you'd want to go for a non-refereed journal. Generally, articles with broad coverage are more prestigious than those with very specific subject matter, but if your piece is very technical and wouldn't be of interest to a broad audience, then it's probably better to go for a specialist journal. The next question is, how good is your piece? If it's your best work, then aim high. Pick the ultimate journal that you'd like to publish with and work backwards. If you don't end up getting it in there, you can try others, and you might receive some helpful feedback in the process for improving it. Do be aware that some journals have sole submission requirements and they do talk to one another. It may mean that there's a slightly longer wait, but generally those requiring it are the better journals, so it may be worth sticking around for it. So, how to write a good paper. There's a preliminary question here. Do you want to go with sole or do you want to write with somebody else? Co-authoring a paper is harder than you think, and personally I would say it's generally better to avoid it unless it's a particularly senior colleague or it's a joint piece of research. If you do go for a co-authored paper, make sure that you get in writing the percentage in which parts each of you have written before you submit. Also, do note that for open access purposes, when you're submitting, the corresponding author, which is not the same as the lead author, that can be changed on the article, has to be the person at the institution with an open access waiver, if that's available to either of you. So make sure that you check that before you decide who's going to be the corresponding author. Make sure that you've got a single research question. A paper which just summarises the law, is descriptive, lacking argument, not explaining how it fills the gap in the literature, won't get published because there's nothing novel there. And make sure that everything in your paper is relevant to the research question. Don't say, for reasons of space, I won't deal with X. It's only your research question which dictates what makes it in. Quotations, generally, the shorter the better, and make sure they illustrate your point perfectly and succinctly. You'll notice that articles written by very senior academics have far fewer quotations than those written by more junior ones. Title, there's a trend for clever titles from literature or whatever at the moment. I won't give examples, but I'm sure you've come across one or two. Journals aren't terribly keen on them. You ought to know exactly what the paper is about from the title, use keywords, and also think of the SEO purposes of your paper to come up in Google searches and things. You want to make sure you include keywords. Obviously, you want to present all sides of your argument. If there's a case which doesn't quite go your way, don't leave it out. Include it and explain how another case could fill the gap or why it's specific to its own facts. These are the sort of nuances that make an article more interesting and show you've considered the topic as a whole. One paragraph, one point. Make sure you can break every paragraph down into a substantive point. And a good tip for this is to go through the article and write bullet points for every paragraph. And that can help you to see that you're building the argument in a logical way, and it helps to ensure the relevance of everything that you're saying. And then on that, also the structure, ensure that you use plenty of headings and subheadings to lead your reader through the argument and make it very clear what you're saying without them actually ever having to read a word. There's a classic saying, say what you're going to say it, and then say what you've said, and that's never a bad idea. There's some articles that will be linked at the end of my presentation, which are quite helpful for further reading. The Samuelson one is particularly helpful on structure. Footnotes, generally add these as you go along, use them for every quote, make sure every assertion that's not a direct quote but taken from someone else's writing. Look into programs like EndNote, which will, at the click of a button, change the formatting style of your footnotes from one style to another. It takes a bit of getting used to, but once you have, it's invaluable for future writing. Clarity is crucial. Simple phrases are preferred, short sentences. Resist the temptation to use flowery language. If you look at the appendix on page 269 of the Volok article, which I've also linked, that has some good tips, and the Marumba article is also good on what makes good writing. Introductions. It's worth noting the abstract and introduction are not the same thing. Too often I read the abstract and then read the introduction and realise I've read the exact same thing twice. The abstract should be very short, what it's about and the main point. The introduction does much more. It sets up the literature review, your research question, the structure, and it should be in a martini glass formula, hence my nice picture. You go from the broad to the specific. So you have a general introduction to the subject, placing it into context, identify the specific issue, briefly explore the existing literature, 2 to 3 sentences, but you want to aim to point out that there's a gap which you're going to fill with your research question. Say what that is, very brief mention of methodology and structure. Obviously, with legal essays, methodology is generally just how you answer the question. You don't need a specific methodological approach, but if it's empirical work, you do need a solid methodology. And then end it with a simple statement of the thesis. It's my argument that, and then make sure that you create a dialogue between that introduction and the rest of the article so that they reflect each other. How to submit your paper. This can be very quickly summarized in check the submission requirements on the journal's website and follow them. I've put a link there to our ICLQ ones, but generally you want to make sure that you've met every requirement. Length, ideally don't go over or under. Make sure you check the total with footnotes. The footnotes should never be more than half and more like quarter. If you go over, offer to reduce it if necessary, but we're talking 2,000 to 3,000 words here, not 20 to 30. It's not the editor's job to tell you which bits need to be cut to make your article good. You must conform to house style. If you're submitting to multiple journals, and only say this if it's not a sole submission journal, obviously, you can say that you know that the formatting needs work and you'll do that if accepted. But generally, it's best to format it whilst writing in the style of the most prestigious journal that you intend to submit to first. Only include what's asked. And make sure you've anonymized the document if requested. Make sure it's in the correct format. Some journals want them in Microsoft Word, some want PDFs. The ICLQ always wants Microsoft Word because then it's easier for us to edit the document. Possible referees. There may be an option for you to suggest referees, and feel free to suggest them yourself if you're asked, particularly if your area is quite niche. Obviously, don't suggest anybody who's your immediate supervisor or has any other bias. Generally, it's best to avoid saying who you don't want unless there's a genuine reason, if so, describe it. For example, so-and-so differs in opinion to me on X, so they substantially disagree with the premise of my article, so that they're an unsuitable reviewer. You would never say X doesn't like me or X is too critical. And once submitted, be patient. It's very difficult when people ask for me to tell them how long the process is going to take. It depends on so many factors, how many people you have to try before a peer reviewer will agree, how long it takes all those people to reply to you, how long the review then takes, whether further reviews are necessary. It's very difficult to say. If you have a specific deadline, for example, your research funding requires that you publish by the end of the year, make this clear in your submission, or better still, contact the journal beforehand to ask if it's realistic. At least 6 months prior to the issue you'd like to be in, more realistically 12. So the peer review process will be looking to see, is it an original contribution and is it well researched and written? This is the general flow at most journals, or a close variation of. The assistant or managing editor checks the paper to see if it's within the subject area and of a sufficient level. If you get a reject decision very quickly, it's usually going to be for one of these 2 reasons, and it's best at this stage not to ask for further feedback. It's quite hard for the journal to say it just wasn't good enough, and it won't have had a detailed review that would then provide useful pointers for you to help revise it. So at that stage, it's best to just try a less prestigious journal. It then goes to the editor-in-chief with peer reviewer recommendations, then sent out to peer reviewers. Generally, these will be external, but if we have internal expertise on the board, we may also send them to somebody on our editorial board. Once the reviews are returned, if the reviewers are very clearly in agreement, then we'll usually make the decision at that point. If there's disagreement or any nuance in the decision or a further review is needed, we'll seek it at that point and then have a discussion with the rest of the editorial board as to how we proceed with that article. We meet quarterly, so generally we do this in person, but we also have the facility to do it online in between board meetings in order not to hold things up. And then finally, you'll get your decision. I've just briefly noted the types of decisions here. The wording varies from journal to journal. These are the ones that the ICLQ uses, but the categories and the meaning of the categories is roughly the same. Reject, unfortunately, the meaning of that is obvious. A reject, but with an invitation to resubmit. A lot of people don't see this as a positive thing, but it means that they see potential in your article, but there are things that are needed to get it through to being publishable. So it's a really good idea to actually resubmit in those circumstances, and make sure that you make all the changes requested. And accept with mandatory revisions. Obviously it's in, but you've got some work to get it up to standard. And again, you must make these. Accept with minor revisions. Sometimes it can be, these are mere suggestions and it's up to you whether you want to do them. Sometimes they're just mandatory revisions, but there's not a lot of them. So the editor will usually say which it is, but generally it's usually better, unless you disagree with them, to make them. And you can push back if there's something that a peer reviewer has said which you don't feel is relevant to your article or doesn't quite understand it correctly. You can always go back to them and say, thank you for this point, but I'm not going to address it for these reasons. As long as you've given a reasoned example of why, then it's fine to push back. But the recurring theme is, if you're asked to do something, do it. Editors and reviewers are usually highly knowledgeable and experienced, so any suggestions they're making will be improvements to your paper. Particularly listen with regard to word count. There are no parts of your paper that are so important they can't be cut when compared with none of the paper being published at all. So what happens next? You have the publishing process. Usually there may be editorial comments on your paper. Again, it's best to accept these. Make sure your paper conforms to house style at this point. It then goes to production. You'll likely have to sign an author publishing agreement in some form. This is when you consider what kind of open access you want. Proofs, it's very important. These are only for checking typos, spelling, missing words. This is all your responsibility. It's not the chance to make changes to your argument or substantive edits. And then publication online and in print, usually both. You sometimes get a PDF off print, and a few journals give a paper copy. Post-publication then is your opportunity to tell the world about your paper. You can use institutional repositories and SSRN. Make sure that you check the journal's policy with regards to what you can actually post. The ICLQ has got quite a progressive policy here. You can add the text of the accepted manuscript after peer review, but not the version of record. Many only allow you to post the abstract. Scholarly research networks such as ResearchGate and academia, be a little careful of these. They're commercial and based on selling data, and they can facilitate the illegal posting of content. They're useful to use because they show up well in Google searches, but just make sure that you've checked your journal's requirements and you don't fall foul of these. And then you can personally also disseminate your work via social media, email. Check whether you can share the full text. For example, Cambridge University Press journals, authors can share the full text of their article for free online via a link with CoreShare, which is great. I was going to very quickly cover open access, but I think I'm nearly out of time, Sophie, or could I have another minute?
30 seconds.
30 seconds. Okay. Well, there are two types of open access. Green is the minimum research requirement of many research funders. Almost all academic journals have a green open access policy. Then you can pay to have gold open access, which makes your final version available to everybody. The article processing charge is fairly hefty, but a lot of institutions will have what are known as either transformative agreements or read and publish agreements with various universities, which will waive that fee. So when you're looking to publish, have a look and see whether your institution has one of these agreements with the publisher, which will mean that you don't have to pay that and you can make it freely open access. It's part of the broader principle of open research. There are other ways to engage. Sign up for an open research contributor ID, ORCID, helps build trust and transparency in research and builds up your own scholarly record visible to all, increasingly used by funders and institutions. Choose journals with gold open access possibilities, use recognized repositories. If the article is based on data, make it available in a data response repository, and make sure that you share your article socially. So hopefully now you have a better understanding of the publishing process and might be more confident in turning your own work into articles and submitting them to publication. And I very much look forward to receiving some of them at the ICLQ. Thank you.
Thank you very much, Anna. Thank you very much for, I think these are very concrete explanations about the publishing process, and there's also plenty of good advice there about how to structure and organize ideas. You mentioned that the ICLQ is so I'll just say a few words and we'll take a few questions before asking Paula to discuss specifically comparative law submissions. You mentioned that the ICLQ is a top journal for comparative law, and my question is, okay, so would you have done some broad figures about the outcomes of the reviewing process? Because that means presumably it's quite hard to find a slot in your paper.
Yes. We receive 300 to 400 articles per year, and we publish an average of 40. So that's roughly a 10% total acceptance rate. In 2022, we only received 302 articles, which is at the lower end. 25% of those were rejected immediately, which seems quite high, but when you consider that peer reviewers are harder and harder to find these days, it's important that we really only send the articles with a genuine chance of making it to publication out to peer review, so as not to abuse people's generosity and time. Of those going to peer review, 5% are accepted as is. They are very rare. I feel the data is somewhat skewed because of the way that our data bank pulls things, but it's generally very few. 3% we ask for minor revisions, 8% are mandatory revisions, and 7% are revise and resubmit. So if your maths is good, you'll realise that the vast majority following peer review are then rejected, 77%. So that sounds a little bleak, but the reality is that we simply don't have the capacity to publish everything that we'd like to. So even things that are rejected are often good articles, but perhaps they're not quite right for the journal, or they're too specialist for our particular audience. So it doesn't mean that it's not a good paper.
Thank you very much. And I'm assuming it's not really possible to distinguish between comparative law submissions per se and others.
It's not, unfortunately. We've been trying to build the functionality into the system, but we have so many articles which are comparative, but they also are comparative within another field, such as EU law. So so many kind of straddle the various areas, and those are the kind of articles we actually really like, that interact between the various subject areas. So it's quite hard to categorize them, even if we were to have that functionality.
And I had another question, which goes back to your emphasis on introductions, and the structure of the paper. So you spent some time talking about the introduction, but you didn't say anything about the conclusion. And there's often a temptation, I suppose, to just, you've written the piece, you've done the bulk of the job, and how important is the conclusion then after all this work?
I would say it's very important. It's much more than just a summary. You need appropriate closure, and you need to leave your reader with a lasting impression of what your argument is. So you would want to summarize the main points and the key arguments, tie up any loose ends, any unanswered questions. And then this would be a chance to reflect on the significance of your findings. What are the broader implications of what you've discovered, or what you've your analysis? Maybe think about how your findings might inform future practice or research, but you do want to be concise. They don't want to be too long. It's a fine balance.
Thank you very much. Okay, so I'm looking at time, but also wondering whether there were maybe questions here from the audience, some sort of burning question before we ask Paula. But I think if nothing comes up right now, I think we might as well just move on and ask Paula to tell us a bit more about comparative law submissions in particular. And so get ready, and do already, please, if you can, put Q&A questions already in the Q&A section. Thank you. Paula, over to you.
Thank you. And thank you for the invitation. It's good to be here and to see so many attending, which is great news for us at the ICLQ, because we are obviously very keen to get your contributions to our journal. As Anna has said, we do have high standards, but we do welcome contributions. And if you are published in this journal, it's something that's respected globally, and we do have good dissemination assisted by Cambridge University Press. So we want to encourage everybody here today to contemplate contributing to our journal. Let me tell you a bit more about the, thank you, the ICLQ. If I can just close my pictures. As you can see, we deal with not just comparative law, but also public international law, private international law, human rights, and EU law, but also there may be an overlap between them. So comparative law may be traditional comparative law, or it may be an overlap with those other disciplines. And as we know, as comparative lawyers, there are many different types of comparative law. We obviously are not confining ourselves to traditional comparisons. We take a very broad approach to that, which I think is only right in the 21st century. This information is taken from the website, which gives you an indication that we're looking for comparisons, so more than one system. But also, we do have obviously an obligation in each edition to have different articles. So on that basis, long articles should not exceed 15,000 words, which allows us to publish more articles. And we also have short articles of up to 8,000 words, which I will talk about in a moment. And these both are word counts, including footnotes. Equally, we use the Scholar One platform, which you can find a link to. It's a very useful platform. Many journals actually use it. So you'll be familiar, for example, with legal studies, and other journals use the same platform. It is very straightforward. But again, if you do have any problems with submission, email Anna and she can take you through it. So what are the key questions you may want to consider when thinking about contributing to the ICLQ? Well, from my perspective, I obviously involved in the comparative law side of the journal. Is your article comparative? Is this something you want to engage with? If it's not comparative, it's based on one other legal system, just one legal system, then think about other journals. As Anna indicated, one reason we sometimes reject articles is they just don't fit within our remit. And it can be a fantastic article, but if it's on, for example, a very technical aspect of intellectual property law on one jurisdiction, then we would suggest perhaps you want to target an intellectual property law journal, because that will get you your required readership. Equally, what we would suggest, and this is again something we're familiar with both in our own work and in advising students, is that have the word limit in mind when you're writing. So you don't write a hugely long piece and then have to chop it up to try and fit within the word limit. What is your research question? Think about the word limit when you're writing. That will make everybody's lives a lot easier. Equally, there is an option of a long or a short piece. And one thing we do want to emphasize is that short pieces can be fantastic. They are not of lower quality, but they just have a narrower research question. And so we have a great piece that came out recently by Johannes Ungerer, looking at consideration from a very interesting bidirectional Anglo-German approach. This was a shorter piece, but it was very focused, and I think makes a contribution both in terms of its analysis, but also in terms of comparative law theory. And a high quality piece, but was regarded as a shorter piece. And indeed, bearing in mind everybody's shorter attention spans, maybe shorter pieces may have more impact. Equally, we are very international in the authors that we attract. And if you do need assistance with your English, no problem with that. But we do have information there about preparing your materials. So again, if you are worried about the quality of your English language, there is a way of dealing with that. We do try to publish globally, and obviously are open to all good quality work. We do, however, ask that your work is original, previously unpublished, and not currently under consideration for publication elsewhere. Again, this is something that we've had in the past, and publishers speak to each other. Reviewers sometimes review for more than one journal. So if it is under consideration somewhere else, we often find out, and it may raise issues in terms of who you end up publishing with, what feedback you get. So do bear in mind that you should only submit to the ICLQ as your sole target. Further considerations you may want to address are which systems are you going to look at? And again, more than one, please. But do bear in mind, it's not necessary to include the UK. So we've had pieces on Australian, US, and European Union law. So again, it's not necessary just because we're a UK-based journal to have the UK or England, Wales, depending on your discipline, as a comparator. But the choice of jurisdictions must make sense to the reader. Equally, there are different methodologies you can use. Again, we do not discriminate against that. In fact, we welcome diversity. But one issue is, and I'm going to talk about this more, is that what we are is a general journal, although focused on international comparative, private international law and EU law. So people will pick it up and they'll want to know about it. And don't be so specialist that there's only 3 people in the world that will understand what you're trying to say. Clearly, your article will have more impact, more people will read it, if, in a sense, you take the reader with you and make sure that what you're discussing engages a broader audience. Equally, we need, this is a basic skills base, to show that we are dealing with reliable sources that are up to date and show a good knowledge of the relevant scholarship in the field. So think about your reader. Think about who is going to read that. Is it clear? Is your argument lucid, coherent? Is this something they can engage with and read, even if they haven't read as much as you and don't have the skills base that you obviously have? Also, and again, this is something that comes from experience, both as somebody who contributes articles as well as reads them, is think about your reviewer. The reviewer is going to read this. They're going to look at what the article sets out to do, check that your central concepts are clearly defined, look at the evidential base for your arguments. If you can anticipate what your reviewer is going to look for and give them that, then clearly it's going to be a lot smoother in terms of the review process. Now, we use a double anonymized model of peer review, so neither the author nor reviewers know the identity of each other, which I think is really important. There will be experts in your field, but if, for example, your piece is actually perhaps theoretical, but also raises practical issues, the reviewers may come from different disciplines, so we get feedback on the different elements of your article. But look at what they're asked to consider: the contribution to the discipline, academic rigor and accuracy, and the style and structure of your paper. And if we think of the REF criteria, REF looks at significance, originality, and rigor. So the kind of things the ICLQ is looking for in your paper are also, we hope, likely, if you are under the remit of the Research Excellence Framework, likely to score you higher in terms of the factors that lead to a high REF score. So do bear in mind that one of the problems we have as writers, as academics, is that we put forward our arguments, but they benefit from feedback. They benefit from engagement, and peer reviewing offers a chance for sometimes leading people in the field, experts, to read your work, read it properly, sit down and read it from cover to cover, and then give you suggestions for improvement. And it's free. So again, if we can see it as a constructive experience, then there's a lot to be gained from peer review. Equally, and this perhaps is more applicable for people starting off an academic career, think about a book review. Now, when I started off, this is my concern. I get a free book, I get to read ideas, and I get a publication out of it. Longest publication in the world, but it's a good way to start academic writing, particularly if it's in a very good journal. So book reviews are, I think, beneficial for you as a scholar, and they're a way of engaging with other writing in your discipline. And ICLQ welcomes book reviews. And as you can see, that if you have a suggestion, do contact Anna. There may be somebody else already writing on it. So although we do say you can upload your review if you want, I would check with Anna first that nobody else is reviewing it. But again, if you could indicate that you have some kind of expertise in this field and an interest, we would really welcome that. And again, we do have a member of the board that deals with book reviews and will give you feedback, help you structure it if you've never done a book review before. So again, there's a lot of positive help there, particularly for younger scholars. I'm going to end my presentation with a number of success stories. These, I think, are great pieces of comparative law, which are published in the ICLQ, but are very different. And again, it shows the breadth of what we do and the fact that if it's good quality research, this is exactly what we want. So Sandra Fredman's piece, fantastic piece, is on human rights law. And you'll notice that she's doing a number of things in this piece. She's actually thinking using a deliberative perspective. She's looking at a number of very different jurisdictions, which she uses because she sees they have broadly similar institutional frameworks. So she justifies why she's looking at this. And it's a piece that actually thinks about it in a theoretical approach using practical examples. And I think, again, this is a piece I often use for students as a very good example of a very skilled comparative law, but with a message, actually seeking to achieve something. Mindy Chen Wishart's piece from 2013 is perhaps a more traditional comparative piece in that she's looking again at a theoretical idea, that of legal transplants, but with a practical example of a functional approach towards undue influence, comparing English law and Singaporean law and going painstakingly through the cases to identify diversity, seeing commonality, and then drawing out a theory thesis from that. Again, excellent scholarship, doing something very different to what Sandra Fredman was doing, but nonetheless a high quality piece. The last example I'm going to give you is something that won the Young Scholar Prize. And we haven't spoken about that, but every year we award a prize to a young scholar who has published in the ICLQ. They get invited to our annual lecture. And clearly, this is a way in which we spot the stars of the future. And T.T. Arvind, who many of you may know, in 2010 was a star of the future. He is now a star of the present. He's a fantastic scholar. And his piece on the transplant effect in harmonization, again, using harmonization of law and arbitration, a very specific example, looking at harmonization theory, but also bringing in the idea of transplant effect. And as you can see, again, using very diverse comparators, India, Egypt, Nigeria, to bring out an article which is thought-provoking, I think really excellent in its execution, fantastically well structured, and again, an outstanding piece we were very, very proud to publish. So what I hope I've done in my short presentation is given you an idea of the diversity of what we cover, the basic things to think about, and to encourage you to think about sending your work to the ICLQ. Couple of points. As you said already, very few people get accepted unconditionally. Most of the time you will get feedback. And actually that feedback is very useful. And again, this is clearly anonymized. We had a piece of comparative law, which was good. I would say 3-star RAF, but we gave this person feedback that came back not just with taking on board that feedback, but redrafted some of the piece, and it was an outstanding piece, clearly 4-star. So feedback there made us feel very happy because we had felt we'd been constructive and made one of the 3-star piece into a 4-star plus piece, which was actually outstanding by the revision. So being accepted unconditionally, unless it happens to be something that you are very proud of and have perhaps had feedback from your colleagues in your institution, is very rare. Equally, if you get revise and resubmit, it's happened to us all, please do that. You will get feedback. You will get a lot of support as to what you need to do. Usually there's a good reason for that. And if you take that on board, think about it. And again, think about it. Don't just send it back 3 days later, but try and find the time to rethink about what you're being asked to do. The piece will be assessed. And again, we've got a good number of revise and resubmits that have now published in the journal. I obviously will not identify them, but they're very, very good pieces. So see submission as an opportunity to get feedback on your work. We all need it. Not all of us are lucky enough to have institutions that give us that, but it is something we hope will improve it. And our mission really is to encourage and publish excellent comparative law work, which we can all read, which hopefully is a very noble ambition. Thank you.
Thank you very much, Paula, for all the positive vibes and the encouragements. There was a lot in that talk too. We've got a few questions there in the Q&A already, so I'm going to go through them and invite more people to raise questions. There's a few points which perhaps are slightly outside the remit of this seminar. The first question is, how different are the publishing guidelines for journal and books? What division at Cambridge should one submit a book manuscript to?
We are not representatives of Cambridge University Press.
Yes.
I can deal with that very briefly. It's a very different process, and the best way to go about it is to identify the senior commissioning editor at the press that you want to submit to, and contact them. But yes, I'm not going into it today, but it's what you have to produce for a book proposal is very different to how you would go about a journal article.
And so, having been in touch with CUP quite recently, I can tell you there's a number of commissioners for law publishing, and they each have an area of specialism. So you just target the person, contact the person you're interested in publishing with, and then there's a lot of indication on their website. But yeah, this is slightly beyond what we're doing. But there was a further question about the ICLQ here from Stuart Manley, who says, my admittedly superficial observation is that the ICLQ has a bit of preference for foreign investment law articles, especially in comparison with, for instance, public international law. Could you please comment? Thank you. So again, we're focusing on comparative law specifically, but I suppose it goes back to the question about the balance between comparative law and other areas as well in the publication process.
I think we read what's submitted, and I think Anna will agree that we've had quite a lot on investment. I mean, I've had to gain some experience myself reading them, which has been very, very interesting. It goes in waves. We will read any comparative work that's submitted to us. If it's interdisciplinary, really interesting, we think it will interest our readers, it's very well done, then it will get published. So I don't think we have any priorities, we just read what we get.
Yes, absolutely. We're at the mercy of what's submitted to us. If it's good enough, we will then publish it, and we don't really have much control over the balance of that, because we're not actually going out and asking people to write on the areas that we don't have enough material on, although we are here today asking you to submit your comparative law material. So maybe we do a little, but never specific topics. So really the balance of what's in a particular issue, we do try and make sure that we cover all of the areas, but we can only publish what we have.
Thank you very much. And there was another question, which is, what is the best time to make a submission? So I don't know how we define best time, but do you want to have a go at this?
We accept submissions on a rolling basis, so there's not a specific deadline per issue. The best time to submit your article is when you feel it's ready. And I would say ready would include having had colleagues look over it, perhaps friends who would be prepared to be critical, because even if they're not lawyers, they can help you identify whether you have done enough to describe your argument to the generalist reader, whether you've made it easily comprehensible to someone who's not an expert in your field. So that's an important tip before you submit to a generalist journal, I would say. But yes, generally I think it's around 3 months between submission and publication, assuming that the peer review process is fairly swift and there's not an extensive sort of second round of reviews. But it can be up to 6 months. It can be even longer if multiple rounds of revision are required. So it's really very difficult to sort of say when you should submit if you want to publish in a certain issue. It just doesn't work like that.
Okay, thank you. That's very helpful. There's a question about what are the recommended sources for journal rankings? Yeah.
The one that I mentioned and that's most often used is the Thomson Reuters impact factor, and they have a law list. That's probably the main one that's most used. There's also Skimago, and Google Scholar also ranks journals in law. And the Research Excellence Framework also has a list of UK journals ranked. So those would be probably the main ones to check.
Thank you. And we have also a specific question about how embargoed manuscripts or materials are identified and respected.
I'm not really sure how to address this because it's not a situation that has arisen in my 10 years as editor. Perhaps the person asking the question could be more specific, but it's generally not really an issue that we've encountered.
All right, so we're waiting for that person perhaps to ask further questions or explain what they have in mind. But in the meantime, I wonder whether I can come back to some of the points you made, Paula, and maybe Anna also has things to say there. But you talked about the constructive engagement with the peer reviewers, both of you. Now, even before that, is it a good idea to submit the text to a critical friend, or yeah, do you have any advice there?
Well, I think, as Anna's already said, if you can speak to colleagues who can advise you on an informal basis, particularly, again, if you're a PhD student, talk to your supervisor. If you're an early career researcher, talk to your mentor or somebody else in the staff that's working in the same discipline as you. They will give you friendly feedback. And often the most obvious tripping points, the things that, you know, it's so obvious you needed to sort it out, such as you haven't numbered your paragraphs or your footnotes don't work, they could pick that up. And therefore, when it gets to the journal, you are burning on all cylinders and you're giving the very best production that you can actually do. So yes, if you can get that feedback, I'm conscious of the fact that not everybody is in a position where they can get that. But if you do have a person who can help you in that way, then obviously that is very supportive of the institution, and it will hopefully make the peer review process even more successful.
But you also talked about, you know, to give the example of Sandra Friedman's article, which seems ideal in the sense that there's a theoretical approach here, but, you know, something really interesting theoretically. There's also a wide range of jurisdictions being considered. So in terms of the balance between depth and coverage of analysis for a comparative law perspective, do you have any advice, or is it really a question of ad hoc analysis there?
It really depends on what you're trying to do. I was reviewing a piece recently and somebody footnoted the fact that you are only allowed to have 4 comparators and gave a source, which I thought, well, where does 4 come from? It depends what you're doing. So the Ungara piece, they use 2, but they drill down into those 2 and deal with it in great depth. And I think that is really fantastic, and using them as examples of different common law and civil law traditions. Whereas if you're talking about human rights and processes, then again, more jurisdictions, particularly for the ones that have very strong constitutional impact, is what you want to achieve. So the main issue for comparative law is, why are you choosing them and what do they do to enhance your analysis? So I'm always very wary of, you must use 4 or less comparators. You could only use 6. You could only do this. I think you really need the confidence to think about why you are writing comparative law, because as I always say to my students, comparative law isn't easy. You're making your life twice as difficult or 6 times as difficult as just writing about one jurisdiction. It must be doing something to enhance and improve your article. So if you bear that in mind and think about it, then the answer should be logically there for you. Again, very obvious point, if you have a word limit, then clearly you need to be able to reach the depth needed within that word limit.
Okay. Thank you. And I suppose I had a question also about, because you raised some questions about that you ask a student to think of, but what is your advice to your PhD students in comparative law about how to get published in this field?
Well, again, the book review tip is, when I'm doing private lawyers, I say write a case commentary. Book reviews, you're reading fantastic books and you're getting published. And often starting off with a shorter piece makes publishing a larger piece more manageable. So again, think about a short article on something that perhaps is a chapter of your PhD or DPhil. Baby steps sometimes gets you there. So don't think that the first article you have to write is 15,000 words sorting out the world's problems. It can be something that is actually more confined, but you build up your skills base. And also talk to me, get me to read it. I'm very happy, obviously, to read my PhD students' work, but also other people's work. So use your network, get the feedback. And that actually can help. The other point is, say you have a wonderful Society of Legal Scholars conference appearing in June. Speak at conferences, get feedback from conferences. Speaking at conferences improves your networking skills, get your ideas out there, you get feedback, and can again get the kind of comments peer reviewers might raise before you write the article. So in a sense, you're getting ahead of the game. So use opportunities. Also, I believe there is an annual workshop by the British Association of Comparative Law for doctoral students. And again, that's a fantastic forum to test your ideas, and you can get feedback from professors who also assist at that annual workshop. So again, a plug for BACL's workshop, which many comparative law professors and academics started their careers at, presenting their doctoral work.
Thank you for this reminder, Paula. And indeed, I want to say that we did have a discussion about publishing during that RPG workshop, and so it follows very nicely. You talked earlier.
Sorry, may I just very briefly mention, follow up on Paula's point about short articles. We actually get far fewer submissions of short articles than we do longer articles. So in terms of your chances of being published, if you've submitted a short article, they're higher, significantly higher, I would say. I don't have the statistics, but it's definitely easier. And some people think of them as being lesser because they're shorter, but actually it's just that they're dealing with a more specific point, not the broader arguments that a longer article would be. So I would definitely encourage you to begin with short articles, because, as Paula says, they can help you to hone your craft. And it's also good to have experience of publishing with a journal before you write your single big, first article that you hope is going to kind of make your name, if you've got that background experience. So that's worth noting.
That's very worth noting. Thank you. Going back to one point you made earlier, Paula, about the number of comparative jurisdictions, that the question here in the Q&A about the justifications for the choice of jurisdiction, what justifications for the choice of jurisdiction tend to be more successful in the review process?
Well, first of all, have one. There's nothing worse than seeing that somebody's looking at Australia, Vietnam, and Peru and thinking, well, why? So address what you're trying to do. And it should be logical once you've explained it. So again, we are a very broad church, so I don't think there's one single justification, but it has to make sense in the context of what you're writing about. So the main problem is not doing it, or doing it in a rather facile way, which is I'm looking at a common civil law and I've picked these two. Again, it has to be more than that. But as long as you're addressing that, as long as it makes sense and actually is seen again as using the comparison to deepen and enrichen the analysis, then that's fine. So it's not a magic formula, but it's something that people do need to address.
Okay, thank you very much. And there's going back to the Q&A before taking a question from either there. The elaboration of the point raised earlier by an anonymous attendee. I have written a manuscript with novel and niche material due to considerable circumstances. I have had to embargo the text. Nonetheless, there has been much interest in my text, and I have very unfortunately seen some of it referenced or not in several places. So the institution it is embargoed with has been very good to resolve the breaches, but the monitoring of it is not 100% effective. So I suppose it's about your processes in dealing with that kind of issues.
We don't have a specific policy on this. As I said, it's not something that comes up often, but obviously it would be viewed by myself, the editor-in-chief, and then the two anonymous peer reviewers. who wouldn't know your identity, but we wouldn't be able to consider it without sending it out for peer review. So it would have to be seen by other people. Then it may need to be discussed by the editorial board. But we could ask all of those people, make them aware of the situation, and ask that they don't disseminate it. But I think it's a given that they wouldn't anyway. We would just do our best to work with you in the circumstances, but it's not something we have a specific policy on, I'm afraid.
Okay, thank you very much. And question, going back to the point that was made earlier, that it's all about taking the reader with you and engaging with a broader audience. So could you define your audience in terms of locations, objectives, please?
Well, we want as wide an audience as possible, because obviously we want to disseminate. It has to be a global audience. It will be from undergraduate university students to learned professors, to barristers, practitioners. The idea is, if you realize that you're not just talking to solely comparative lawyers who are doing your theme, but actually a broader audience, then the voice will be a lot clearer, and you will actually have more impact with your readers. What we want is people to read it and enjoy it, not just 3 people who have the same knowledge that you have. So therefore, I think it's in everybody's interest, if we think more broadly about the aim of publishing an article, is communicating your ideas to the wider world. And the more people that can engage with them, the better for you. And again, part of the reason for publishing is improving your networking, getting your work out there to people across the world. So the more accessible it is, the more your networking will widen.
Thank you. May I ask a question, a broader question, or procedural questions about the process, going back to that? And it is that, could you clarify, you're talking about the blind process. Could you tell us a bit more when you discuss the embargoed possibility of looking at embargoed manuscripts? I'm assuming a blind process for reviewing articles, but at what stage are articles anonymous for review? And more generally, in terms of, is there such thing as an equality and diversity here policy in terms of the composition of the editorial boards? Could you tell us a bit more about that?
Yes, well, all of our articles that go out for peer review are double blind reviewed, which means that the reviewer will not know the identity of the author, and the author will not know the identity of the reviewer. We're very careful to make sure that documents are anonymized before they go out. Quite often people will have remembered to remove their name from the top and redact any footnotes that say, "See my earlier work," with their name in, but they won't have realized that their Word document has them as the author, and you can see in the properties who has written the document. So we're careful to make sure that all of those identifying factors are removed, so that it genuinely is anonymous, which means that any decision about an article is made based on it's not there's no discrimination as to personal characteristics or identity, because that's not something that the reviewer is aware of. Every article is judged solely on its own merit. So the background of the author just doesn't come into the decision. In terms of diversity and inclusion on the editorial board, obviously it's a factor that we consider. We review the composition of the board on a regular basis, and do aim for diversity, but we need to ensure a good spread of people between the different disciplines that the journal covers as well. So it's something that we think about, but it's balanced with other factors.
Okay, thank you very much. I think there's also quite a lot there. I've touched on all the points that I really wanted to touch, and we've had some really good questions. I'm looking at the Q&A, and I can't really see the audience, but if you do have any further question, it's your moment. But if not, then I think I will bring this session to a close. I think, sort of speaking slowly to see whether, here we go.
There is one more.
Always when you do that. Okay, so how is the ICLQ addressing ChatGPT, etc.?
That's a very good question, and one that we're dealing with at the moment, working with Cambridge University Press, who have their own policies on this. They are very aware that AI is increasingly being used in academia, and they are quite accepting of the fact that this is the case, and rather than taking an approach which bans it completely, they are simply asking authors to make sure that they have declared any use of AI technology, the platform that they've used, how they've used it, and how they've incorporated it into the text. This is something that authors will be asked to declare upon submitting the manuscript. And it will also be something that we ask them to put in the acknowledgements, because it's one thing for the editorial board to know whether AI has been used, but it's quite another for the audience, the reader of the article, knowing whether that's knowing the technological use that's been involved in the production of the article. So it's something that's happening now and will be a change that will be coming in over the next couple of issues. But we haven't had anyone declaring their use of AI yet. I imagine it's going to be happening soon, because it's a very hot topic among in academia, and we are dealing with it as proactively as we can, whilst hopefully being realistic about the fact that it is going to increase.
Thank you. That's a really, really difficult issue. So thank you. Okay, well, I think it's time to bring this session to a close. Let me see what's coming up in the Q&A. Thank you very much. So here we are. Thank you. So on behalf of the audience, thank you so much to our two members of the panel for your very full and very inspiring answers. I think we learned a lot. There's a lot of information there. I hope there was a little bit of myth busting at the same time, and it's very inspiring to know that we can aim high, and you give us, I think, a number of tools to think about achieving publication with the ICLQ. So thank you very, very much, and to next time. So just to conclude, just to remind you that I hope to see some of you at the SLS. We do have a comparative law seminar there. Have a look at our website, and so until next time, thank you very much and goodbye.
Thank you, everybody.
Thank you.